The network made an unparalleled contribution to quality, diversity, and equity by hosting guest talks with judges from the Supreme Court of Ukraine during the Russia-Ukraine War, as well as the Supreme Constitutional Court of Palestine and Supreme Court of Israel during the peak of the Middle East crisis. 70% of participants during Global South Network activities since its launch in March 2023 were women. We demonstrate the Global South is not a passive recipient of ideas but an active contributor shaping global norms. Today we are privileged to host Honourable Justice Michail Pikramenos, President of the Hellenic Council of State, Supreme Administrative Court of Greece.
I don't like the long presentations and the long speeches. Dialogue is better than monologue. The case law of the Court of Justice, the European Union and the Strasbourg Court has been instrumental in modernizing national approach to important issues in the field of rights. There is a violation of the European law. The Special Supreme Court, our court, was wrong, in very simple words. Public trust in the European judiciary varies significantly from country to country. However, the level of trust cannot be viewed as distinct from the general differences between high trust societies, mainly in the northwest of Europe, and low trust societies, mainly in the south and east. Historical, social, and economic reasons account for these differences. Trust is the bedrock of any successful operation, whether it be private or state. Judiciary is not in competition with other branches of power, but it is fundamental that trust established and there is a recognition of its independence in the way of its function.
Deseo expresar mi sincero agradecimiento al Dr. Naumen Riaet, la conferencia dada por el magistrado Michail Pikramenos, presidente del Consejo de Estado Helénico de Grecia.
Dr. Naumen Riaet, the founder and convener of the Global South Network, his visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally.
I would like to point out that Dr. Riaet's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism. In these days of backsliding of the rule of law, rising authoritarianism and polarization, it is of utmost importance to strengthen mutual understanding and trust.
Despite the fact that Russian armed forces have been near Kiev, the Cassation Court did not stop its operation concerning judicial proceedings and continued its work. Despite the Russian invasion and air alarms, other horrible things of war in all our Ukrainian regions. To express my appreciation for your assistance, for your help in our fight against unjustified war.
Supreme Courts are sovereign. We can rule where we want in the cases which are brought to us by citizens and residents. In the EU, this openness of mind is increased by the fact we apply, in some cases, same norms from the EU treaties or the EU directives or regulations.
Initiative.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperation. Global South Network provide a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is, I believe, the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Now, allow me to invite our second discussant, Honourable Justice Molemela, President of the Supreme Court of Appeal of South Africa, to share their comments.
Thank you very much, Honourable Chair, for giving me the floor. I want to extend my heartfelt appreciation to Dr. Norman Riat, the founder and convener of the Global South Network, for inviting me to participate in this critical dialogue. His visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. I would also like to express my sincere gratitude to the Honourable President of the Hellenic Council of State, Justice Michail Pikramenos, for his insightful lecture on the Hellenic Council of State and its role in the European legal order. His reflections underscore the importance of administrative courts in safeguarding the rule of law while balancing national and supranational obligations. I can say without fear of contradiction that these insights are both valuable and thought-provoking for the legal community in South Africa and probably across the Global South. The Hellenic Council of State operates within a distinctly European context where national administrative law must align with European Union law and the jurisprudence of both the European Court of Justice and the European Court of Human Rights. In contrast, some courts outside the European Union, such as the South African Supreme Court of Appeal, operate differently. In South Africa, our administrative law is primarily anchored in Section 33 of our Constitution. The Promotion of Administrative Justice Act 3 of 2000, commonly referred to as PAJA, was enacted to give effect to the constitutional right to just administrative action. While foreign authorities may have persuasive value, our ultimate responsibility as South African judges is to interpret administrative justice within the framework of South Africa's constitutional order. With that said, Section 39 of the Constitution clearly provides that the courts must consider international law. So that is obligatory. The exercise of public power must be lawful and reasonable, and all processes followed to reach a decision must be fair. This is how public officials are held accountable. Another notable difference lies in institutional design. While the Hellenic Council of State serves as Greece's Supreme Administrative Court, the Supreme Court of Appeal of South Africa is not the final arbiter in administrative law disputes. It functions as the penultimate appellate court of general jurisdiction. According to Sections 16 and 17 of the Superior Courts Act 10 of 2013, only complex appeals should be heard by the Supreme Court of Appeal of South Africa. Thus, the judgments of the Supreme Court of Appeal often represent the first significant appellate consideration of complex legal issues, including those related to administrative law. However, it is the Constitutional Court that, as the apex court, holds ultimate authority on all matters. The Constitutional Court frequently builds upon or affirms the reasoning of the Supreme Court of Appeal, emphasizing the latter's foundational role in shaping administrative law jurisprudence. Considering that until 2013, the Supreme Court was the apex court in respect of all legal disputes, barring cases in which constitutional issues were raised, the Supreme Court of Appeal has played a significant interpretive role in determining whether a decision constitutes administrative action subject to judicial review. There are two judgments that you can consider. The one is Grace Marine Hout Bay, Pty Ltd and others versus Minister of Public Works. It's a 2005 judgment of the Supreme Court of Appeal. There is also a judgment of in the matter Democratic Alliance versus President of South Africa. It's a 2012 judgment where the issue at hand was the rationality of executive decisions concerning administrative appointments, specifically regarding the appointment of the National Director of Public Prosecutions. The Constitutional Court confirmed that even the most senior executive actions must meet the constitutional standard of rationality, a principle that protects against arbitrary decisions. As I conclude, having observed the broader landscape, I am struck by how themes from various jurisdictions resonate globally. It is evident that in legal disputes involving administrative issues across Europe, Asia, Latin America, and Africa, courts encounter remarkably similar challenges. These challenges extend beyond geography, legal cultures, and institutional designs, emphasizing the need for international cooperation among supreme administrative courts worldwide. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally. Ultimately, the pursuit of justice is a shared endeavor. I thank you.
Thank you, Honourable Justice Mahube Betty Molemela, President of the Supreme Court of Appeal of South Africa, for your wonderful contribution.